Good morning, everyone. My name is Nancy Isserlis. I'm the Vice Chair of the Washington State Public Disclosure Commission, and I will be the presiding officer for today's hearing. We need to make sure everybody's on mute until they're called, please. I hear some background noise. Today is April 18th, 2023 at 10 a.m. This hearing is being conducted under the authority of RCW 34.05, the Administrative Procedure Act, WAC 390-28, and RCW 42.17A, the Campaign Disclosure and Contribution Act. This hearing is being held by teleconference through Microsoft Teams. These proceedings are being video and audio recorded. Today, according to my agenda, there are 5 matters on for brief enforcement hearings. In each of those cases, the PDC staff has provided a written record for each case, and each respondent has had an opportunity to appear via Microsoft Teams or by phone, or may submit a statement in writing and waive their right to appear. We have at least one person who is joining us who has a modification matter. At this point, we have on the agenda that if anyone who is not having a case adjudicated today wants to make a public comment statement, we have reserved room on the agenda for that. So I'll entertain any public comment in advance. I just would say that anything that is said in public comment is just that, it's comment. It's not evidence that will be considered by me in making any ruling. So I believe if I look at who's up there, we probably have comments from Connor Edwards. So I would ask Connor to make those at this time.
Okay, thank you, Chair Isserlis. I just wanted to comment quickly on 2 of my PDC complaints that will be decided today. In both of these cases, we had candidates who ran in 2018, were required to file disclosure reports with the PDC, and failed to file a single C3 or C4. And obviously that was a failure on their part. However, the fact that these cases are only being adjudicated today, over 4 years after these candidates appeared on the ballot, that is a failure of the PDC, and the agency should take steps to correct that. Both in states with relatively strong disclosure laws, such as Hawaii, and in states with relatively weak disclosure laws, such as in Idaho, it would not have taken over 4 years for a candidate to be penalized for failing to file a report on time. In those states, these candidates would have faced monetary penalties before the election was over, when those penalties could have made a difference. That is because most agencies actively and meaningfully enforce campaign contribution and expenditure disclosure deadlines, and this agency does not. This agency does a great job enforcing the requirement that folks file F1s and L2s and L3s, but the truth is that very few members of the public know that these forms even exist, and even fewer people care to look at them. Enforcement of these requirements should not take precedence over enforcement of C3 and C4 reporting deadlines, but unfortunately they are, and that should change. I want to quickly comment on the recommended penalty of $150 in both these cases. I am shocked that agency staff would recommend such a low penalty against the candidate that completely snubbed their nose at PDC filing requirements for an entire campaign cycle and still has not filed the required reports over 4 years after they were due. This penalty is simply not enough to deter people from engaging in the same behavior. There was an almost identical case against another candidate who was on the 2022 ballot, Robert Amen, case number 111937, and he was fined $150 with instructions that he filed the required reports. Well, nearly 5 months after he was fined and after the election, he still has not filed a single report, including his F1, and he still hasn't even paid the fine. I reached out to the enforcement staffer who handled that case, and she made it clear that while the $150 bill was going to be sent to collections, the agency wasn't going to do anything to force him to file the forms that he is required to file. So in effect, these penalties are being treated like indulgences. Once a candidate is fined, they are only required to pay the penalty, and the PDC does not ensure that they actually file the required reports. And I think that's wrong, and I think that needs to change. But that's all I've got to say, so I'll go on mute and listen in. Thank you.
All right, thank you for those comments. At this time, I think the only two staff we have presenting cases today are Kurt Young and Tabitha Townsend. So can we both get sworn in at the same time? There's something right in the middle of my screen that I can't get rid of. And that makes me, oh, there it goes. Okay. Sorry. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I do. Thank you.
Thank you. Oral recording of that's very important part of the proceedings. All right. The first matters up are modification renewals, and Tabitha Townsend will be handling those. So take it away, Tabitha.
And I just want to check the audio for Miss Azuri. If you can unmute yourself so we can make sure your audio is working. If you're called in, it is *6 to unmute yourself.
Are you able to hear me at this point?
Yes.
Great.
Yes, perfect. Okay, so you will be sworn in prior to testifying, and I will do my presentation, then you'll be sworn in. I just want to make sure that your audio got fixed.
Thank you.
No problem. Okay, so this is a modification renewal request for Jennifer Azuri. This is for the annual F1 report for calendar year 2022. This is Judge Azuri for Benton County District Court, elected November 2022. The current term expires December 31st, 2026. And attached in the packet was the prior order so that you could see that, as well as the modification application and the current F1. Judge Azuri is requesting a renewal of her reporting modification that it would exempt her from disclosing all of the reportable business customers that paid $12,000 or more during the reporting period to Wildland Labs, Inc., doing business as Brand Craft, of which her spouse is Chief Executive Officer and has a 26% ownership interest. Wildland Labs, Inc. is a marketing company located in Richland with 20 employees, annual sales of 1.7 million, and more than 50 customer accounts. Judge Azuri indicates that some of the customers are publicly available as provided in the list of reportable governmental customers as part of her personal financial affairs report that were known to her at the time of her filing. Judge Azuri states that identifying all reportable business customers would cause a competitive disadvantage to the company located in a small community. She does agree to recuse herself if a conflict was to arise between Wildland Labs, Inc. and Benton County District Court. There is confirmation that Wildland Labs, Inc. received no payments from Benton County District Court. She has reviewed her initial reporting modification request and certifies that there's no changes from those facts from the prior approval. And you could grant the modification through her current term, if so desired. And I'm available for questions. And Judge Azuri is here.
Tell me when that current term expires. Did I hear 2026?
Yes, December 31st, 2026 would be the end of her term.
Okay.
Mhm.
All right, Judge Azuri, would you raise your right hand and be sworn in, please? you affirm that the testimony you'll be presenting today will be the truth, the whole truth, and nothing but the truth in the event that I have any questions for you?
Absolutely.
Good morning. Is there any material change from the last modification request that was granted?
No, there may be slight changes regarding some of some of his clients, my husband's clients. But the main issue remains the same. And I guess my stance on it is that I would continue to recuse myself to, in regard to any of those clients, just in the appearance of fairness.
Okay. I don't have any further questions for you, Judge. I find that the modification renewal request is appropriate, and I would grant it through the balance of your existing term to end on December 31st, 2026.
Okay.
And I think
Thank
that's
you.
all we have for you this morning.
Yes.
Well, wonderful. Thank you for working with me to get me on the phone. I don't know why I don't have a microphone here in Prosser, but I appreciate you working with me.
It's okay. That's why we have you join early so we can take care of technical issues if they arise. Yeah.
Perfect. All right. Thank you very much.
Thank you.
Thank you.
Bye-bye.
Bye.
The next matter is Ian Burke, Judge Burke.
Yes. So this is a modification renewal request as well for the annual report for calendar year 2022 for Judge Ian Burke. And Judge Burke is part of the Court of Appeals Division 1, appointed May 9th, 2022. Current term expires December 2028. And this is a two-part request. So there is ownership interest and the former law firm clients. The first part, Judge Burke is requesting a partial reporting modification that would exempt him from disclosing the business and other governmental customers that paid $12,000 or more during the reporting period to American Association for Justice, AAJ, and the Washington State Association for Justice, WSAJ, where he served as Board of Governors during the reporting period. Judge Burke states that AAJ and WSAJ are national and state nonprofit professional associations for lawyers, primarily representing plaintiffs in civil cases. They generally do not engage in sales of goods or services, but do present continuing legal education seminars attended by individual lawyers. Judge Burke states that prior to his judicial appointment, he has asked both organizations if there were any reportable customers. He did not learn of any as a board member and believes that information to still be accurate. In addition, Judge Burke attests that he no longer has access to any customer lists for either organization and states that it is exceedingly rare for these entities to be involved in any type of legal proceedings that would come before the Court of Appeals. The second part is that Judge Burke is requesting a partial reporting modification that would exempt him from disclosing the business customers or clients that paid $12,000 or more during the reporting period to his former law firm, Keller Rohrbach LLP, for the period of January through May 2022. Judge Burke was an attorney with Keller Rohrbach LLP prior to his appointment to the Court of Appeals. Keller Rohrbach LLP has approximately 60 lawyers in offices in Seattle, Phoenix, Santa Barbara, Oakland, and New York. Judge Burke states that it would be both a hardship and likely impinge confidentiality or confidential information to disclose the purpose of the legal representations. He further states that he had knowledge of and worked on matters for only 2 of the reportable clients of the firm. In addition, he attests that he no longer has access to the client names or payment information. Judge Burke states that clients are listed publicly in class action cases, litigation documents, and on the firm's website. He also stated that he does not believe that any of these clients are reportable. Judge Burke states that some payments were made with a confidentiality agreement due to personal insurance involvement. Also, Judge Burke has listed other governmental customer, City of Seattle, and business customers that he is aware of on his F1 report. He states that his position terminated May 7th, 2022. So he has agreed to recuse himself in matters that may come before him regarding Keller Rohrbach LLP and the organizations AAJ and WSAJ and the Court of Appeals Division 1. Judge Burke has reviewed the initial request, and there are no other changes to the facts related to his request other than what's been stated. And Judge Burke's request could be granted through the current term of office as allowed in RCW 4217A 120 Section 1 and WAC 390-28090. And I'm available for questions. I do believe the law firm part of this request would only need to be granted for this report, as they would not be required on further reports.
Okay. Do you know if Judge Burke has stood for election since his appointment? Did he get appointed midterm?
Yeah. Yes, and then he was elected, and hence the term
Okay.
going all the way to 2028. Sorry.
Yeah,
Yes.
that's because they usually they have 6-year terms, and so I thought, that's odd. Okay,
Yeah.
all right, that answers that question. And we don't have Judge Burke with us on the meeting today.
No.
So based on the report and evidence that you have submitted, I will grant the modification renewal as requested. The first part, well, I'll do it in reverse order. The first part, the client issue will be granted for this calendar year.
Mhm.
And the second part will be granted through the end of his term, that being December 31st, 2028.
Perfect. Thank you. And we have one more modification. And Mr. Manning is not in attendance today. So this is a modification renewal request for Jay Manning. This is for the annual report for calendar year 2022. Sorry, that jumped around on me. The prior order modification request and current F1 were attached for your review. Mr. Manning is requesting a renewal of a reporting modification that would exempt him from disclosing the business customers that paid $12,000 or more during 2022 to the law firm Cascadia Law Group, PLLC. Mr. Manning is an attorney and partner at Cascadia Law Group, PLLC. In his previous request, he stated that Cascadia Law Group is a small firm with offices in Seattle and Olympia, with 7 staff members that provide administrative and legal assistance support. Mr. Manning stated previously that he had more than 10% ownership interest but is not involved in the day-to-day operations of the firm. Mr. Manning has provided a list of his clients whose interests would be significantly affected by his actions as a trustee for Eastern Washington University, clients who are identified in court files or other public sources, and the firm's governmental clients for calendar year 2022. Sorry, that was a error on the cover sheet that I will correct. Mr. Manning has agreed to recuse himself if a matter came before him involving a conflict of interest between Cascadia Law Group PLLC and his duties as a trustee for Eastern Washington University. Mr. Manning has reviewed his initial reporting modification request and has certified that there are no changes to the facts related to his request. And if approved, you could grant the request for 3 years of his appointed term as allowed in RCW 4217A 120 Section 1 and WAC 390-28090. With the Regent trustee, the longest we can approve those for is 3 years.
When was he appointed, Tabitha?
He was appointed. That should be on here. I do not have that on here.
Is it 3 years or through the date of his 3-year term?
So his term actually goes through December of 2027,
Okay.
but the classification of his position is only allowed for a 3-year approval at a time.
Okay.
Mm-hmm.
All right. And I'm looking at the folks who are on the meeting, and I don't see that Mr. Manning has joined us. Based on the information you've provided and the testimony that you've given today, I find that the modification renewal is appropriate and it will be granted for a period of 3 years.
Okay, perfect. Thank you. And that concludes the modification section. I'll turn it over to Kurt.
All right, Kurt, we have 2 matters up that are assigned to you. So we'll take the first one, which is Raymond. I'm not sure how you pronounce his last name. It's CLOUGH, PDC case 111409.
Thank you, Commissioner Islis. I believe it's Clue, but I will go with that pronunciation for the.
I would not have said it that way, but I'm glad to have stood corrected.
Sounds good. This is the enforcement matter for Raymond Clue, PDC case 11409. On May 2nd, 2018, Raymond Clue filed a candidate registration declaring his candidacy for the office of Klickitat County Commissioner in 2018 as an independent candidate, selecting the full reporting option, listing himself as the campaign treasurer. Mr. Clue was a first-time candidate in 2018. Despite selecting the full reporting option, Mr. Clue failed to file any C3 or C4 reports during the 2018 election cycle, and staff confirmed that his name appeared on both the 2018 primary and general election ballots. On August 4th, 2022, the PDC staff received a complaint from Connor Edwards, alleging violations of 235 and 240 of the statute for failing to file C3 and C4 reports. Staff conducted a review of that. No response was received from Mr. Clue in response to this. He did respond prior to the hearing date, which I had included the incorrect date in there, or we canceled that and rescheduled it, and I have not heard anything from him. Based on that, PDC staff is alleging that Raymond Clue, a first-time candidate for public office, seeking the office of Klickitat County Commissioner in 2018, violated RCW 4217A 235 and 240 by failing to file monetary contribution report C3 and summary full reporting contribution and expenditure report C4 reports. Mr. Clue has no prior PDC violations. Staff could not find any other complaints or notifications that he had failed to file the reports during the 2018 election cycle. And Mr. Clue, 2018 candidacy was his only election in which he's been a candidate in Washington State. While email is our official means of communication, staff used the 2018 email address that Mr. Clue provided and sent multiple email communications, including the initial hearing notice and the initial hearing results in November, notifying Mr. Clue that the matter had been updated from a review to a formal investigation. As noted, one day prior to the previously scheduled brief hearing for March 29th, Mr. Clue left a voice message and an email response. I responded to those, asking him to provide a summary of his activities. He asked staff to present him with blank C3 and C4 reports. Staff did not do that. He's required to electronically file. Staff attempted to ascertain what his level of activity was so that we could maybe assist him in filing that, but never received a response back. Staff recommends that the presiding officer find that Raymond Clue violated RCW 4217A, 235, and 240 by failing to file any C3 and C4 reports during his 2018 campaign for Klickitat County Commissioner as a candidate under the full reporting option. Staff recommends that the presiding officer assess a $150 civil penalty in accordance with WAC 390-37-143. That's the brief hearing penalty schedule. And that is consistent with the penalty for a first-time candidate with no prior PDC violations. And staff recommends that the $150 penalty be payable within 30 days of the date of the order. I'd be happy to answer any questions that you have. As noted above, I could not find that even the incumbent spent a whole lot of money on this race. So the incumbent was David Sauter. He paid a filing fee and then reported $150 professional photographer expense. So that was the level of activity from the incumbent. So based on that, staff feels the $150 penalty is appropriate.
That was the only expense reported by the incumbent?
Was the filing fee and a payment
Photographer?
to a professional photographer. No political advertising that I could find on his reports.
All right. That must be how they roll in Klickitat County. And Mr. Clue is not here today, although he was in contact with you at some point.
That's correct. He did respond through email and to the ticket, but never provided a formal response or indicated any more information as my follow-up from the previous correspondence.
And the suggested penalty that you're recommending is in accordance with our standard penalty schedule?
Correct. $150 for a first-time filer that has no prior violations.
Okay. And I have a question that's probably, I'll ask both Kurt and Kim this question. Is there, this is from 2018. That's when he ran for Klickitat County Commissioner. Is there anywhere in the statute or the WACs any kind of statute of limitation on our authority?
There is. It would be 5 years from the date of the violation. So we're not up against that yet. That would be, likely, if he owed us a C3 and a C4 for the primary of 2018, that would be, due in July of 2023. So we're within the statute of limitations, but thank you for clarifying that.
Wanted to make sure I wasn't violating the law myself. Okay.
If you
Tabitha?
if you have Kim testify to anything, make sure and swear her in. Sorry.
I will, but she didn't. I think all she did was nod her head, and I won't take that as testimony.
Yeah. Yeah.
Kurt was able to answer my question. So with that in mind, based on the evidence submitted today and in writing, I will find that Mr. Clue has violated 4217A. It's unfortunate that it took this long to resolve this matter, and I can assure anyone that's listening today that we're aware of this issue as commissioners and certainly the staff, and have this in mind as we move forward to make sure that things like this don't drop through the cracks going forward. I'm going to impose the suggested fine of $150. I am not going to suspend any portion of that, given the lack of response from Mr. Clue and the amount of time that has passed. And I will order that that be paid within 30 days, and if not, it be processed for collection as we normally do.
Thank you, Madam Chair. Our next matter will be Donald Golden, PDC case 11418. On July 12th, 2018, Donald Golden filed a candidate registration declaring his candidacy for the office of state representative in the 27th Legislative District, position 2. In 2018, he ran as an independent candidate, selecting the full reporting option and listing himself as the campaign treasurer. Similar to the last matter, despite selecting the full reporting option as an independent candidate, Mr. Golden failed to file any C3 or C4 reports during the 2018 election cycle. On August 4th, PDC staff received a complaint from Mr. Edwards that was filed against Mr. Golden, alleging violations of 4217, 8235, and 240 by failing to file the C3 and C4 reports as required during the 2018 election cycle. PDC staff is alleging that Donald Golden, a first-time candidate for public office in 2018, seeking the office of state representative in the 27th Legislative District, position 2, violated RCW 4217A, 235, and 240 by failing to file C3 and C4 reports as required for a candidate under the full reporting option. PDC violations or complaints were filed against Mr. Golden, and his campaign for state representative in 2018, similar to the last matter, was the only election in which he is filed as a candidate, and I could not find in having any record of Mr. Golden being a candidate either prior to or after the 2018 election cycle. Similar to the last matter, we used the 2018 email that was provided by Mr. Golden without a response. November 1st, we notified him that we were holding an initial hearing and opened a formal investigation into the matter. Mr. Golden did respond in an email and Outlook in January 16th, stating he never heard back from us, assuming the complaint was satisfied. I responded back saying the next day, no, I can't find that you ever submitted a response. This matter has not been resolved, asking him to, provide an email with, some kind of brief summary of his activities during the 2018 election cycle, so staff would be able to advise him on how to report that. No response was received. We sent the initial brief adjudicated proceeding hearing notice and enforcement memo for the initial hearing in May. That was, in March. That was rescheduled for today. As of today, I still have not received a response or a summary of Mr. Golden's activities. Based on that, similar to the last matter, staff recommends that the presiding officer find that Donald Golden violated RCW 4217A, 235, and 240 by failing to file any C3 and C4 reports for his candidacy for state representative during 2018 as required for a candidate under the full option. Staff recommends that you find and assess a $150 civil penalty in accordance with the WAC 39037-143 for a first-time candidate with no prior violations, and that the $150 penalty be payable within 30 days of the date of the order. I'd be happy to answer any questions that you may have concerning this matter.
I don't have any questions, and I see that Mr. Golden is not present with us today. And having assured myself that we don't have a statute of limitations problem for my previous questions, I will find, based on the testimony and evidence submitted in writing, that there has been a violation of 4217A for the failure to file the required forms. And I will impose the fine of $150, which is from our standard schedule of penalties, and order that that be paid within 30 days.
Thank you, Commissioner Islis. That
And I
concludes
think-
our enforcement matters for today.
I think that concludes the agenda that I was provided with. Thank you, Tabitha and Kurt, for those very concise presentations. I appreciate it. It's 10:40. We're going to adjourn 45 minutes ahead of schedule. So thank you all.